One of the craziest cases that I have ever seen has just gotten crazier. As the woman accused of faking twins multiple times, mind you, has said, hey, there's no pregnancy, but you know what? I don't want to answer any of your questions if the public might actually get to hear them. Now, the response to this is a huge win, too, because publicly it calls her out for faking evidence. It says, this is a con. This is a scam. You don't get to walk away. You and I, we're going to cover this today. Crazy fun times, huh? Crazy fun times indeed. All right, so hey there to all you fine folks on this fine day. By the way, I hope you are doing excellently. So one of the craziest cases of alleged false allegations I have ever seen just got a whole lot crazier as the person that allegedly faked twins, faked medical evidence, faked sonograms, faked a moon bump, a pregnancy belly, just got put on blast after they decided, hey, I don't have to show up for deposition. She got absolutely hammered in court documents after her answer for not coming into the courtroom to take deposition was saying, hey, I have the right to confidentiality and a protective order, with her admitting, and this is what gets her put on blast in big time, that the parties here do not share a minor child in common. Therefore, she shouldn't be embarrassed. She shouldn't get put on blast. She shouldn't have to answer questions or turn over any documentation at all. Now, this, of course, gets put on blast and big time, and should be, in my opinion, by the way, with the response saying this takes away my free speech. Not only does it take away my free speech, but you've already been denied this. Why? Well, you're the one who contacted the media. You're the one who decided to disparage the person that you were going after. So what if you have a background in doing this? So what if you fake things and actually have been called out on a scam or a fraud upon this court? Oh man, this is scathing. Listen to this here. Quote, response or objection to petitioner's motion for confidentiality and preliminary protective order. So Clayton Echard, through his counsel, so his lawyer is responding to this, hereby provides his response and objects to petitioner's unverified motion for confidentiality and preliminary protective order. As a threshold matter, petitioner requests relief under Rule 53 constitutes an impermissible prior restraint of protected speech. Beyond that, it also represents tremendous overreach in the use of Rule 53 to diminish respondents' rights as a litigant. Apparently, petitioner feels that she is entitled to what is essentially a backdoor motion to seal after this court has already denied her. So they've already said, no, you can't do that. They did it on this date here. Why did they do that? Well, that's because after she contacted tabloids, and she did. She contacted The Sun. She contacted many other places too, and the media to disparage respondent. The publicity she initiated backfired when it was exposed that she had engaged in previous pregnancy fabrications. So they're saying, you did this before. You have a background in it. And that her quote-unquote medical evidence was lacking in science. The entire underpinning of her petition to establish paternity was predicated upon a con/scam and a fraud upon this court. So she went after Clayton Echard. She went after him based on a lie, and he has the ability to question this. This is his right. Petitioner has furthered her noxious agenda by failing to appear at a properly noticed deposition. They give the date there. This occurred notwithstanding 3 different attorneys. They point this out many times too. Her attorneys, they keep vacating. They don't want to be on this trial in a matter of weeks, having discussed the deposition and ongoing discovery issues. Meanwhile, she continues to advance meritless lawsuits against the media for questioning the narrative she shared with The Sun. So, She's suing people. She's going after YouTubers. She's threatening other folks with a narrative that she put out while simultaneously contacting the media. So she's still engaging in going out at the media again while she's trying to silence folks here. Now petitioner has the chutzpah to flout court rules and suggest this court ignore the First Amendment, while in the same breath arguing that she is entitled to protection by the court. Now this call out gets even worse, because after pointing out, hey, what about my free speech? This notes she shared this stuff with the media. She even wrote a de facto op-ed furthering her fictitious narrative and painting herself as a quote-unquote victim. Now, absent the petitioner's motion is the fact that she filed this underlying motion. She did this, but she also threatened repeatedly to bring her alleged quote-unquote pregnancy to the media. Then she reached out directly to the media with her unsupported allegations. That would include The Sun. That would include People Magazine, TMZ, Reddit, and Medium. And the petitioner published information, including her alleged medical records about the case online. Petitioner now continues to contact the media to advance her fictitious narrative while simultaneously asking this court for special accommodation for confidentiality. This after the court already denied her motion to seal. And also, just a note here, the petitioner's effort to seal the other case with nearly identical claims of being pregnant with quote-unquote twins and similarly doctored sonograms, that was also denied protection. So you can see the call out. It's like, you did this stuff. By the way, that other case where you did the exact same thing, you can't hide behind that either. Now, then they call out the idea that annoyance or embarrassment is something you get protected from, saying, we have the right to ask these questions. We have the right to ask about fictitious pregnancies in the past, the right to ask about appearances in court with a fake pregnancies comic, collateral proceedings, etc. And you're the one that did this. I mean, listen to this. Not only is respondent entitled to the information and discovery necessary to defend against her claims, but he also has the fundamental constitutional right to discuss the nature of those claims, just like any other litigant. Petitioner is requesting an order that would prohibit respondent from defending his character in public view, despite the fact that she made his character a matter of public interest and that she self-defines as a public figure. The toothpaste can't be put back in the tube. Moreover, that the public is interested in this case only adds weight to maintaining transparency, not limiting it, even if petitioner now finds that interest uncomfortable after she invited it. Now, this goes on to call out specific instances where they allege that she's faking certain things, like the fact that a petitioner appeared on video during trial on October 24th, 2023, wearing what appeared to be a moon bump, a device used to appear pregnant, and asked the court if she could show respondent her pregnancy stomach, which the judge was like, nah, they would promptly deny that. On November the 2nd, 2023, petitioner testified that she was 100% and 24 weeks pregnant by respondent, and that she was due February 14th, 2024. Petitioner specifically testified she was having a high-risk pregnancy. She actually gave the names of 2 doctors that were supposed to be attached to this. To date, petitioner has provided no verified information that supports these allegations, other than doctored sonograms ostensibly from Etsy, a borrowed YouTube video of an actual sonogram, and positive HCG tests. Then they call out the lies, saying, you just file a motion to dismiss, saying for the first time you're no longer pregnant, but you don't tell us what happened. You don't provide any evidence, and we don't trust you because of your history of lying or your history of arts and crafts medical evidence, and we're not going to take written discovery. That's not sufficient. We want to ask you questions. And just because you're afraid of perjuring yourself or getting called out for filing false police reports, yeah, that's not enough. In fact, you should be afraid. That's actually good cause for us to ask these questions. They want to ask questions, too, about relevant topics like past relations in which she engaged in the same activity. They say, there were similar threats there, similar legal actions brought by her both in writing and in prior litigation, emails and texts that she sent to other men with nearly identical verbiage, prior doctored evidence, and also how she has gone out and how she has gotten attention with this stuff too, saying factual matters similar about which petitioner authored editorials, TED Talks, podcasts, and also they should be able to talk about her medical and associated health conditions.